Hello my friends, welcome to Canadian Immigration Channel. Lots of you are asking me if it is possible to appeal the decision of federal officers who cancelled or rejected your application for a temporary resident visa. In other words, if you're applying for a tourist visa to Canada, you're visiting your relatives, friends, whatever the reason is, and you were refused, there is a chance to appeal this refusal, provided that officers made a mistake in your process. And so here's exactly how it works, step by step, how this application is supposed to be processed if you're looking to appeal. Well, this pathway, just a quick disclaimer, is not working for each and every one of you, but there is a way if an officer made a mistake, if you believe that officers made a mistake, to make this way or to revert the case. So say you receive a refusal, which is quite unfortunate, and if you in your refusal letter you got a few reasons marked by an officer, please keep in mind that this is just a boilerplate. So an officer is looking at this standardized refusal letter and is marking whatever he or she believes appropriate in your case. This is not an explanation why your particular circumstances, why your documents were not satisfactory enough. Now, in order for you to understand what's going on, you have to get case notes as soon as possible. Preferably the very first day you receive this rejection, you have to get case notes which would explain what exactly went wrong and what exactly did not satisfy an officer. Example is, and this is by the way the real one, the person has visited 62 countries, so he is a genuine tourist, right? He's been traveling throughout his life, he's been visiting a bunch of countries, he's got more than $1 million in his account, and one of the reasons for refusal, the officer remarked, not sufficient funds. So okay, we're looking at case notes which were issued within 30 days, and mind you, you get 60 days to file a notice of appeal to the federal court. Now, what we have is we got those case notes within 30 days, we're looking at them, we analyze them, and we quite realize that either the officer did not understand whatever he or she was marking in there, or that was a refusal just for the sake of refusal. Okay, well, we got two options. Either we would resubmit the application and make a note for the next officer, whoever would be looking at it, to point those mistakes, or we could go to the federal court. In case we decide to go to court, we have to first file a notice, right? The application for leave, which means that we are kind of asking the court to consider the case and decide whether it is just enough for the court to give it a go, if you will, right, to process it. So there is a chance the court would say, no, it is absolutely worthless, there is nothing to appeal here, officers were right. Another opportunity as well, the court says, yes, there is a chance that the officers were not just in their processing, if you will, and the court will decide to give it a go. Now, at this stage, CIC, Minister of Citizenship and Immigration, will have their right to file documents back, to explain themselves, to file their reason and why they believe that they made this decision correctly. Now, another opportunity, they might actually not file anything. They would say, okay, let's go to court, let us process it, right? Again, if your application for judicial leave is successful, meaning the court is taking it for processing, there are two possible outcomes. The most common one, when CIC decides that they actually made a mistake, well, at this stage, they might actually send you a notice saying that, like, all right, we will reconsider it. So let's just take the application back from court, right? Let's just forget about it for a second. We will reconsider your file. Now, there is a chance that they will give you an opportunity to submit additional documents for your new application, and this application would be considered by another officer without any prejudice. So there is a very, very high chance that your visa application would be approved. Another circumstance, it goes forward, and after several months, the court decides that CIC was wrong, and in this case, the court gives an order to CIC to reconsider this application, which is, again, fine. Well, the third outcome, which is negative one, right, was when the court decides, no, you're absolutely wrong, and in this case, the officer was right. So this is a chance for you, and unfortunately, it's quite an expensive one, right, because it requires lots and lots of work, lots of documents preparation, but if you're looking to appeal the decision of immigration officers, well, this is your chance to move forward and go ahead with it. If you want us to work on your side, if you want our legal representatives, our lawyers to work on you and defend you, feel free to send us an email. We will have a consultation. We will discuss how to proceed further, whether reapplication would work perfectly fine, whether asking a case review to look at the case under a different angle would work, or it would be an application for judicial review, which is again would work for you if it's necessary. Stay tuned for that, subscribe for the channel, and don't forget, well, to send us an email if you would need us.